Good morning, my name is Amy Dasanaika and this is my colleague Mitchell Schneider. We are here to provide you with a presentation covering the topic of child support and child custody. The Family Law Act 1975 is primarily focused on the rights of the children and the responsibilities each parent has in terms of caring for their child rather than the parental rights. The law is mainly concerned with the protection of the child from both physical and psychological harm and stresses the importance of both parents being involved in their children's lives. The type of arrangement that suits the child's best interests is determined by the court who has considered the many relevant factors which will be discussed later on. Through these arrangements, the law encourages the parents of the child to look at the child's best interests when agreeing on an arrangement for where the child will live, how they will be supported financially, and what their relationships with their parents will be like. The Child Support Assessment Act allows the primary carer of the child to make a claim for child support from the other parent. The duty of the Child Support Agency is to manage child support arrangements and assess the amount of support that each parent should be providing. The end decision is based on the parent's income, the number of children they have, and what their living arrangements are like. There are 3 child support options available depending primarily on your financial circumstances and how well both parents are able to negotiate the terms of child support. The first type of child support option available to parents is a child support agreement. This is when both parties are able to agree on the amount of child support that each of them should be paying and signing a written agreement to put that amount into a contract. The Department of Human Services then administers that agreement and collects and distributes the payments as stated in the agreement. Binding child support agreements are written and signed by both parents. A binding agreement can only be entered into on legal advice, which must contain a statement to the effect that each party has received independent legal advice as to the effect and advantages and/or disadvantages of the agreement before it was signed. This kind of agreement is not accessible by the Department of Human Services. Parents can choose what amount they think is appropriate. Unlike binding agreements, limited child support agreements do not require legal advice. This type of agreement must have also had an administrative assessment conducted by the Department of Human Services at the time the agreement was entered into. The annual rate of child support payable under the agreement is at least the annual rate of child support that would otherwise be payable. A parent who cares for their child at least 35% of the time is eligible to apply for a child support assessment. The child support payment amount you receive will depend on the calculation of the formula, which will be described later on. If you continue to live with the other parent on a genuine domestic basis, you are not eligible to apply for a child support payment. Provided that you care for the child for a minimum of 35% of the time that you are the child's legal guardian, you are able to apply for a child support payment. There are 3 different categories of child support payments: periodic payments, non-periodic payments, and a lump sum provision. Periodic payments are made directly to the other parent or carer on a regular basis and can be adjusted to reflect the changes in the cost of living. Non-periodic payments are when the court or agreement makes an order for non-periodic payments, for example, a payment of school fees to third parties. They are indirect payments. These could also reduce the annual rate of child support payable, which must be stated. For example, if the school fees are $3,000 for the year, the agreement needs to say whether the annual rate of child support is reduced by that $3,000 or a percentage of it. Lump sum provisions are payments made to the other parent as a sort of credit balance to be used to meet ongoing liabilities. These are payments specified by the court or agreement and have stated the percentage of these liabilities prior to drawing up the lump sum. The Department of Human Services assesses how much child support each parent will get by following the steps of a set formula as per the relevant laws. This 8-step formula takes into consideration how much both parents earn and the time each parent takes into caring for the child, and then using these 2 factors into coming up with an amount both parents will owe to each other. This is an assessment that occurs after a set period of time for review and reassessment of all relevant factors in reaching a final amount of child support for each parent. If you would like to access more information regarding this 8-step formula, you can visit the Department of Human Services website. Once a couple has decided to end their relationship, part of their divorce proceedings is reaching an agreement for child support to benefit the children of the relationship. Child support is calculated according to both parents' income, the number of children they have, and the child's living arrangements. It is also determined on the basis of the cost of care of children as well as the level of care provided by the parents. Child support payments as set out by the Child Support Assessment Act is what the law imposes on a parent as their duty in maintaining their children. Child support, which is often also referred to as child maintenance, is a recurring payment made by one parent to the other in caring for and supporting their children. This payment provides a financial benefit for the child. In calculating how much child support each parent is entitled to pay, the following steps listed in this flowchart are what the Department of Human Services takes into account. By following these steps in what is called the 8-step formula, a final amount of child support each parent is entitled to receive is calculated. There is a child support online estimator that calculates an estimate of what child support and family assistance payments are likely to be under the formula. The care and cost table outlines the amount of time each parent spends with their child, which is also known as the care percentage. This cost percentage shows each parent's share of the child's costs, which are met directly through the parent's care. The cost of children table is separate to the care table. This table outlines how children costs are different for each individual. The reason for this being that the parents' combined child support income, the number of children in the family, and the children's ages all vary and differentiate in each family law case. These three factors are also the determinants of calculating the children's costs. The care percentage is based on how much care each parent provides. Usually, both parents are able to agree on the amount of care they both provide for their children. For example, one parent might have care for 56 nights a year, and the other parent cares for the child for the rest of the time. If an agreement is not made between the parents, the Department of Human Services will be able to reach a solution for you. Evidence from both parents will be required to calculate the care percentage for each parent. Such evidence can include a diary or calendar showing when you care for the children, a court order or parenting plan with evidence that what you're doing, what it says, documents that show the children are in daycare, school, or other regular activities, records of visits to healthcare or other services, airline bookings, or passports showing travel dates. I will now hand you over to Mitchell Schneider, who will talk about child custody.
Thank you. I'm here to talk to you today about the concept of child custody and explain the various types of different orders that can be made in a family law court. The current piece of legislation governing child custody is the Family Law Act of 1975. As my colleague stated earlier, it focuses on the rights of children and responsibilities that each parent has regarding those rights. The basic principle of the Act is that children should share in their parents' standard of living and that both parents will have equal responsibility in regards to their child. Due to this, the Act requires that separating parents with a dispute about children make a genuine effort to sort through the issue through a process called family dispute resolution. The family dispute resolution practitioner must provide a certificate called a Section 60I certificate before any applications can be made to the court. However, there are a few circumstances, such as domestic violence and child abuse, where mediation isn't required. When this form of alternative dispute resolution fails, there are a number of options that can be taken in regards to your dispute, including parenting plans, parenting orders, and consent orders. I'll explain these shortly, but first I must discuss the paramountcy principle and how it applies to you. The paramountcy principle applies to parenting orders and is stated as follows. In deciding whether to make a parenting order in relation to a child, the court must regard the best interests of the child as the paramount consideration. While slightly wordy and obtuse, the concept of best interest is really quite simple to understand, as it's broken down into two primary considerations and a number of additional considerations. The primary considerations that the court must consider are the benefit to the child of having a meaningful relationship with both of its parents and the need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect, or family violence. It is important to note that the court has direction to give greater weight to the second consideration. While these are primary considerations, the legislation also sets a number of additional considerations, all in furtherment of the best interests principle above. These include, but aren't limited to, any views expressed by the child, the nature of the relationship with the child with its parents and others, the extent to which each parent has taken or failed to take the opportunity to participate in long-term decision-making about the child, the likely effect of any changes in the child's circumstances, including the effect of separation from either parent or relative with whom they've been living, the difficulty and expense of the child spending time with a parent, and whether that difficulty will substantially affect the child's personal relationships, the capacity of each of the child's parents and any other person to provide for the child's emotional and intellectual needs, the parent's attitude towards the child and the responsibilities of parenthood, and any family violence, whether it involves the child or the parents themselves. Now that you have an idea as to what the court takes into consideration, let's discuss the various options that you have in relation to your child. Firstly, there's parenting plans, which are probably the easiest and most flexible option that you have. Parenting plans require both parents to agree about parenting matters. Thus, they are mainly used when parents have a cooperative post-separation parenting arrangement and do not require their agreement to be filed in court. While usually made between parents of the child, it can also be made between other parties, such as parents and step-parents or parents and grandparents. Certain formalities do apply. The parenting plan must be in writing, signed and dated by both parties, and deal with matters pertaining to the child. For example, their living arrangements and the division of time spent with each parent. Both parents must have a signed and dated copy of the agreement. The flexibility of a parenting plan comes from the fact that it can be changed easily, providing that both parents consent. This makes it a good option for parents with young children, as arrangements may need to alter as children grow older and their needs change. It can be varied or revoked by agreement in writing between the parties to the plan, and a subsequent parenting plan can be entered into. For a parenting plan to be valid, it must be made free of duress, threats, or coercion. A type of more formalised parenting plan is also available. Known as a consent order, it is used where parents would like their agreement to be filed in court. Once the order is signed by both parties and their lawyers and filed at the court registry with the accompanying documents, it has the same effect as a formal court order. That is, it is legally binding and enforceable. While the consent order may contain similar content to a parenting plan, it is not just limited to parenting and maintenance issues. It may also deal with property and financial issues. In cases where the consent order proposes that a child live with a non-parent, the parties must also attend a conference with the family consultant, and the court itself must be satisfied that there are circumstances that make it appropriate. It's worth noting that a consent order is much more rigid and cannot be amended as easily as a parenting plan. Unless there has been a substantial change in circumstances, parties will be prevented from returning to court to seek a new order, due to the psychological damage children may suffer when exposed to litigation and parental conflict. If neither party can agree about parenting matters, a parenting plan or a consent order is of little use, and parents must instead apply to the court for a parenting order. As mentioned earlier, a Section 60I certificate is required before any application can be made to the court, although exceptions apply in cases of violence or child abuse. The parenting order that courts make will generally deal with who the child lives with, how much time the child will spend with each parent, the allocation of parental responsibility, how the child will communicate with the parent they don't live with, and any other aspect of the care, welfare, or development of the child. It is important to note that when making a parental order, the court is required to apply the presumption of equal shared parental responsibility. This doesn't mean equal time or shared care of the child. It means parents must consult with each other and make joint decisions about major long-term issues. These issues are sometimes known as the Big Five and relate to a child's education, religious and cultural upbringing, health, name, and changes to living arrangements that would make it more difficult to spend time with the other parent. Even when the presumption applies and the court orders it, the courts can still order that a child spends most time with one parent. This presumption of equal shared parental responsibility doesn't apply if there are reasonable grounds to believe a parent has engaged in domestic violence or child abuse, and it can also be rebutted by evidence that satisfies the court that it wouldn't be in the best interests of the child for the child's parents to have equal shared responsibility in regards to decision making. In cases of violence and abuse, a parent can apply for sole parental responsibility, which is effectively sole custody, although that term isn't actually used anymore. Should the courts believe shared parenting isn't in the best interests of the child, they are able to give full decision-making power to one parent, which effectively means they no longer have to consult with the former partner about any decisions relating to the child. For a court to provide this sole parenting responsibility, they must be provided with evidence of all matters relevant, such as a total breakdown in communication between parents, any indicator that joint parenting will create more problems for the child than a sole parenting order, reports of the mental and physical health of each patient, and any police or witness reports, if relevant. Hopefully, in this presentation today, we have been able to provide you with some basic information on the processes of child support and child custody. For more information, you can refer to the fact sheet provided, which should give you a useful summary and also contains links to relevant legislation. Thank you for your time.